Arnaud, the floor is yours now.
Yeah, I'm just waiting for the audience.
So we wait a few seconds before you start.
Right. Good afternoon, everyone. And good morning to our audience in Europe. My name is Arnaud Brûla-Couture. I'm a managing partner of LPA Singapore. And I will be the moderator of this webinar alongside my colleague Thomas Chen from the Shanghai office of Mazars.
Hello, Arnaud. Good morning. Good afternoon. We are in Asia Pac.
Good afternoon, Thomas. So today is a unique, if not unprecedented event, because we have the chance to be supported by 4 chambers of commerce coming from Tokyo, Shanghai, Hong Kong, and Singapore. So I would first like to thank all the organizers who made this event possible, and in particular, the French Chambers of Commerce. We also have great panelists that you will see soon on the screen, coming from a big French MNC, Havas. We also have our colleagues, financial experts from Mazars, coming from 5 offices in Asia. And finally, my colleague at LPA-CGR within 4 offices in Hong Kong, Shanghai, Tokyo, and Singapore. So speaking of M&A in Asia, might seem as a challenging topic. And it's true that in less than 1 hour and a half, we will not have the time to address all the questions and topics that we should. So that's why when we brainstorm with our colleagues at Mazars and Havas, we decided to take a pragmatic approach of our presentation. We are here to share examples and situations that we all have faced in the past during our intervention on M&A deals. And the idea is to provide ideas of solutions and how we have addressed and found resolutions of matters in the different situations that we face. So we decided for this presentation to just follow the chronology of a transaction, of an acquisition, and the discussion between a purchaser and the seller. We will start from the stage of the preliminary discussion, leading to the signature most of the time of a non-binding offer or letter of intent. And then we will follow the purchaser and the seller throughout the whole process until proper completion of the transaction. Before I let my colleague Thomas continue this introduction by sharing a few figures and trends about the M&A market in Asia, let me share with you a few logistic points. First, you will see that there is a Q&A feature in this application that allows all the audience to ask questions at any time of the presentation. So please feel free to ask questions. And we have spared 20 to 25 minutes of this webinar to answer your queries. And second, this webinar is being recorded. That will allow each of you to have the possibility to listen to the presentation again. And you will have access to it first in the email you will receive after the presentation, and also on the website of the French Chambers of Commerce. Thomas, I'll let you speak.
Yes, thank you, Arnaud. Thank you very much. So before you start to ask questions to our panelists, I would like just to share with you some figures, information about M&A. As you know, today, why we are talking about M&A with our Asia Asia-Pac panelists. First, you know that Asia is the second largest M&A area. So it's a lot of deals are happen in the M&A. However, in the last 2 years, 2021 and 2022, we have seen, we have seen some big evolution in terms of pricing, in terms of number of deals. So here you have seen in your screen. So in 2021, the total deals is around $6 trillion USD around the world. However, in 2022, the deal is down to 3.8 trillion USD. The reason, I think you may know, first is about the COVID situation, second, geopolitical uncertainties, and the increase of the interest rates. All this impact the number of deals in 2022. Same in terms of valorization of targets. So in 2021, most of the targets average valorization is around 50 times the EBITDA. However, it's down to 12 times the EBITDA in 2022. So this has a big impact on the M&A. However, what we can see in 2023 is maybe smaller deals, but all the deals will be more scrutinized, reviewed. That's why it's important to check to see whether or not it's a good opportunity to purchase or to target some deals in Asia-Pac. So here is my introduction about Asia-Pac and trend about the M&A deals. We can go into the first questions. Arnaud, the floor is yours for the first question.
Yes, thank you, Thomas. It's time to discuss with our panelists. Marie Mbai, thanks a lot for coming today. You are a General Counsel of Havas Group, and the first question is for you. If we follow our chronology, we are at the stage of preliminary discussion between the purchaser and the seller, leading, as I said, to the discussion and the entry in force of a letter of intent or non-binding offer. Non-binding, does that mean that a purchaser and a seller entering into this document have the right to do whatever they want once they have signed the document, including getting away from the transaction? And what are usually the matters that are important for you to address in such a document?
You're on mute, Marie.
Sorry. Hi. Thank you, Arnaud. Hi, everybody. So it is true that from a strict legal point of view, the letter of intent is non-binding. It's written everywhere usually, and except few clauses such as exclusivity and confidentiality clauses. However, at least I can only talk from a Havas perspective. For us, it's a very critical document that we really use to pre-agree on key terms of the share purchase agreement and the shareholders agreement, because for us, Havas, usually the way we buy companies, we buy a majority of shares upfront, but not the whole shares, and then we buy in further tranches later. So we need a shareholders agreement, of course. So we need to agree on the key terms. So the two, and that usually we try to pre-agree now and not to come back later at the transaction document stage. So the two main reasons for us to use it as a critical document, the LOI, first is, I think, a pragmatic reason, because we know that we will incur significant cost when undertaking due diligence in terms of financial due diligence, tax due diligence, legal, IT, compliance, etc. So we want to ensure that we agree on the key terms, especially of the governance of the company post-closing. And the second reason for us, again, as we don't buy 100% of the shares, we need to ensure that we can still fully consolidate the account of the company into our group, which means that we want to be able to recognize, hopefully the profits for 100% and not only 51% that, for instance, we actually buy in terms of shares. And for that, we need to be deemed to have the control on the company from IFRS point of view. And at least on our side in Havas, our auditors are very strict, and they allow us to have, for instance, to give you example, a very limited list of reserve matters, like the veto rights for the minority shareholders, which you can imagine in practice is a very tough discussion, because we get a lot of fair ask from the sellers, and that we can just say no just for consolidation reasons. So it's usually a very hard discussion, and we try to find all the way to address their concerns. And I mean, of course, we need to have the majority at the board of directors. We need to be able to appoint the legal representative, I mean, just without being exhaustive. So that's, yeah, in a nutshell.
Thank you, Marie. That's very helpful and interesting. Of course, Nicolas van der Schmidt, you are the partner of the Hong Kong office. Still talking about the LOI, what we see by experience is we lawyers will sometimes be involved at the level of the negotiation of the LOI, and sometimes we are not. So I ask you the question, is it important to have a lawyer at this stage of the discussion? And when it's not the case to have a lawyer from the beginning, at which point of time it's good to have your legal counsel?
Thank you, Arnaud, and good afternoon, everyone. Well, my experience as an M&A lawyer based in Hong Kong for more than 15 years is that the LOI is a key document, as Marie reminded. So I'm not going to, elaborate on this. But this document, this stage, is too often neglected by sellers and buyers, and of course, this is a huge mistake. What do I mean is quite often we receive, so we are contacted by clients, sellers or buyers, the LOI is already signed. And why is that? Because I guess in the vast majority of cases, the LOI is drafted as a non-binding agreement, and parties may think that they don't need to involve a lawyer. The LOI is not legally enforceable, but this is not right. As Marie said, there are some terms, first of all, of the LOI which will be binding. Typically, when you are a buyer, you would like to make sure that you're going to discuss with the sellers on an exclusivity basis. In jurisdiction like Hong Kong and Singapore, there is no general obligation to act in good faith during the negotiation of commercial contracts, and at any time the parties may stop the discussions, and you will not get damages for any sudden termination of such discussion. So you need to make sure that as a buyer you have a period of exclusivity and that the clause is properly drafted. From the seller side, confidentiality is key. They start discussing and disclose information. So we'd like to make sure that such obligations are well drafted and enforceable. But more generally, even if the LOI is non-binding for most of its terms, it is a key document which will serve as a roadmap throughout the deal. And any deviation from this LOI during the negotiation process will have to be motivated, will be subject to heavy negotiations between buyers and sellers. And each time you would want to change the terms of the LOI, you would give a leverage to the other party. Typically, if the LOI does not provide any details on the liability of the sellers in case of breach of warranties, and you address this issue at a later stage, you will give a leverage to the other party to bargain something else. It's the give and take process. So whether buyers and sellers should involve legal advisors in the LOI discussion, I would say, yes, you need to involve a legal advisor, not necessarily an external counsel. I mean, if companies have internally the appropriate resources, that's fine. What is key is to engage a lawyer, external or in-house counsel, who is familiar with the laws of the transactions.
Thank you, Nicolas.
Thank you very much, Nicolas. Yeah, thank you very much, Nicolas. So when we are talking about LOI from legal part of view, Jean-François, Managing Partner of Mazars Japan, and Cindy, our partner in charge of M&A in Mazars Shanghai. So Jean-François, my question for you, from financial point of view, what is your advice to on the LOI? What we can say the purchaser need to pay attention? And Cindy, from your side, once the LOI is signed, what the target, how the target needs to prepare for the financial due diligence?
Thomas, I think the first thing to say is the LOI is the key to the due diligence. You will not be able to start a due diligence. The seller will never allow you to get detailed information if you don't have a LOI. And that's, you know, I come back to what Nicolas was saying. It's important to have to involve a lawyer, because you need to have a LOI that is binding enough for the seller to have confidence in the deal and open its books, but not binding, not too much binding, so that if you don't like what you see, you can get out of the deal without major costs. So that's the first thing. The second point, you know, LOI, one of the main item of the LOI is the price. You include a valuation for the target, and it's either a fixed amount. Frankly, we don't like it. And if you use a fixed amount, it's important to have a very clear condition and to specify the underlying assumption for the price. But more often, it's a price formula. You mentioned earlier, you know, 12, 15 times the EBITDA. Generally, we have formulas based on EBIT, EBITDA minus the net debt. That's the classical way. And it's a way that enables you to negotiate the price, to adapt the price depending on what you're going to see during the due diligence. But, you know, when you prepare this, you need to be extra careful. The first thing is, you know, very often when you have a price formula or a price, the seller will refer to his own profitability today. Whereas your assumption is about, you know, the future profitability when you will have taken over the company. And there can be a major difference between these two assumptions, specifically if you are in a country where with low level of compliance. It's something like you will have, for example, in China or Vietnam, and I think that Cindy and Laurent will elaborate on that. Honestly, today, I don't see this problem when I'm in Japan, but I spent 11 years doing due diligence in China. And in 11 years, I never had one single case where the Chinese private company was paying completely the social health insurance. That's just an example, but you can imagine the difference in terms of profitability between the present owner doing the business without paying social insurance and you in the future. So if you don't have a business case where you are creating more value through integration, you know, horizontal, vertical integration, to synergies with existing business, you will never be able to justify your price high enough to be interesting for the seller. And this is something you have to recognize when you do the LOI, because as Marie said, you know, the whole due diligence process is costly, take time, take energy. So it's better to know in advance whether the deal is realistic or not. Now, I leave the floor to Cindy for a more detailed description of what we do in a financial and tax due diligence.
Yeah, thank you, Jean-François. About the due diligence, the DD process, the main aim here, I would say, first is to make sure the target you are buying is exactly or actually what you are thinking you are buying. Second, we have to make sure you're buying at the right price. And third is to make sure you're buying at the right conditions, i.e. the impact on shareholder structures, matters to be handled pre-closing and post-closing needs to be dealt with. A typical DD process would start with first, information preparation, financial, tax, legal documents, contracts, etc. needs to be prepared and ready for inspection. Any confidential information shall be treated properly. Second, information sharing, whether it's done on site or through the virtual data room VDR, it needs to be decided. And third, if there is any interviews or Q&A sessions, it needs to be well organized. Issues or due killers we recently seen due to the time limitation of today, I will just give 3 examples. First, say 2 sets of accounts managed, which we see quite commonly in China, one for tax purpose, another one for management purpose. So proper reconciliation between the accounts shall be prepared. Second, as Jean-Francois just say, it would be the compliance cost for social welfare and tax, which is normally one of the biggest adjustments to the earnings. Third, recently we see issues also around the sort of related party transaction. Not just the obvious related party, but sometimes there are, say, shadow related parties, say, employees, companies, relatives, etc. These needs to be analyzed in detail and reflect to the normalized level of profitability of the company. Here, I would also like to highlight the increasing needs and trends of the preparation of vendor due diligence, the VDD reports. Imagine you are in a transaction process under time pressure, and the most difficult sort of process in the M&A is done, and now the buyer presents to you a due diligence report which lists out all the issues about your company, trying to push down the transaction price and negotiate for more favorable terms. So what can you do? I mean, sometimes you can only accept the condition. So VDD is very important and increasing sort of the trends. We see the needs of having sort of vendor due diligence reports.
Thank you very much. Yes, thank you, Cindy. Now let's speak a little bit of the legal due diligence, and I will speak to my colleagues Nicolas, that already spoke, and Fanny Nguyen from our office of Shanghai. Nicolas, first, legal due diligence. That's, by experience, again, a rather cumbersome exercise. How do you work with your team to make this exercise useful for our clients, to draw a proper conclusion, and how do you proceed generally?
Yeah. Well, as for the financial due diligence on the legal side, basically, the target is to identify the main risk of the target entities and make sure, as Jean-Francois said, that what you are buying is consistent with what you think you are buying. So you don't want to end up as a buyer with a company which has not the requisite licenses. It happened in the past. Whose shares are subject to a legal charge. It happened in the past. Whose shares are owned by a third party, which was from a past transaction, a big surprise from the buyer who was dealing with the partner for many years. You'd like to make sure that there is no big litigation, etc. So identifying main risk. And what to do with such, conclusion, I would say, first of all, is when we have identified the main risk, is to make sure that the contractual terms, the protection of our clients is ensured in the SPA. So to make sure that the warranties are well drafted to cover the main risk. Secondly, when we have identified specific risk, to draft indemnities which are stronger, which is a stronger protection, and maybe we'll come back to this later, to protect the buyer against this specific risk. And I would say quite rarely, the outcome may be the reduction of the purchase price, or even to stop the whole negotiation, the whole transaction, if the risk is too high for the buyer to continue discussing with the sellers. One last word about probably the current trend. What we've seen the past 10 to 15 years is the request from buyers is now, try to focus on red flag report, meaning They ask us not to draft a long, exhaustive due diligence report, but to focus on the main risk with an executive summary. And second trend we've seen more recently is the popularity of vendors due diligence, which may accelerate the M&A process, which is launched by the sellers and which can give more comfort to the buyers.
Thanks, Nicolas. Yes, indeed, it's a bit the end of the era of the long form and descriptive reports. And it's true that our clients prefer to have pragmatic conclusions. Fanny, you are practicing in China. China is reputed for, especially for Western purchasers, to be a rather complicated country from a legal standpoint and also compliance, as was highlighted previously. What are the typical matters that you find and identify in your due diligences? If you can put your micro, Fanny. Fanny, we can't hear you.
You are on mute.
Okay, maybe we can switch to the next question, Thomas, and perhaps we'll get back to Fanny in 5 minutes. Fanny?
Can you hear me now?
Okay. Yes, we hear you now.
Okay,
Thank you.
Sorry
for that.
So yes, particularly in China, when we perform a due diligence, we do have specificities and recurrent findings. And what we need to think of is what we are looking at and who we are looking at, because we need to pay attention to the company structure and also to the operation. Just to summarize these two findings, in terms of shareholding structure, what we regularly find, it's complex structure, complex ownership organization. We have limited partnership that are set up in order to conceal shareholders, for instance, family members holding shares on behalf of others, and also for other reasons like to limit the liabilities. It always means that actually you need to have probably a pre-restructuring before contemplating the acquisition. We also see often the setting up of an official shadow stock plan as well between seller and key employees, with the commitment from the seller to grant special bonus to key managers when the new shareholders join the company. This is also very important, and we often see that. So there's a risk to have them as well to quit the company after the acquisition. Regarding the operation of the target company, yes, one of the common findings as well from legal side is the one mentioned by Cindy, underpayment of social charges and remuneration. From a legal side, it leads actually to the question of what do we do after with the employees and how we renegotiate the labor contract, or do we dismiss them? It's usually a hot legal topic. And maybe the last one that is very interesting for China, it's actually even in the industry, what we often see is the non-subscription to any kind of business insurance from the target company. It can be financial losses, liability, unexpected event like lawsuit, physical damage, and most of the companies are underinsured. So it's obviously a major risk for the company that will acquire the target, as if we have to think of in the SPA, otherwise we may become responsible for the damage, property damage, and all the insurance issues that we have.
Thank you very much, Fanny. So as you mentioned, SPA is very important to define all the, we can say, terms between these purchaser and sellers. Now, when we are talking about SPA, we need also to take into account the pricing mechanism. So question for Najla, our director in charge of M&A in Mazars Hong Kong office. So Najla, for you, how to determine the pricing mechanism that works the best for the ongoing transaction?
Thank you, Thomas, for the question. Hi, everyone. Actually choosing the right completion mechanism is, I would say, critical decision in any M&A transaction, because this is how you determine the final acquisition price. Basically, there are two widely pricing mechanism. You have the completion account and the lockbox mechanism. It's worth, I would say, starting by explaining in a nutshell what both mechanisms consist of. So very briefly, you have the completion accounts. So these are a set of a balance sheet and P&L that are prepared post-closing, reflecting the financial position at completion, and they are prepared for the purpose of the transaction. So under this mechanism, the estimated purchase price at completion is adjusted post-closing by reference to this account, so on a debt-free, cash-free basis. So in this context, we are usually asked by our client to review the completion account, review the basis of their preparation, and also their consistency with our financial due diligence outcomes, and also to determine the working capital and the net debt adjustment as at the completion date, based on this in this account to determine the final price. While with the lockbox, it's a different approach. Here, both parties agree on the final price at completion using the target's financial statement at an agreed point in the past. Usually, it's the most recent audited ones, and there is no post-completion adjustment. So I would say that completion accounts remain the traditional approach used for deals, although now we are saying we're seeing the lockbox mechanism is a commonplace in Europe, and is also growing in popularity in Asia here, and especially when financial investors are involved in the transaction, or when parties are looking for a high-paced deal. So I would say identifying the right option for the transaction requires both parties to understand the advantages and the drawback of each option. The main merit of the completion account for sure is the accuracy of the price. So basically it reflects the idea of you should only pay for what you get, but then it also bears a higher risk of dispute post-completion. So that's why the SPA needs to provide for the dispute resolution mechanism. And also this option is also more complex, time-consuming, and disruptive to the day-to-day business of the target. So overall, the lockbox mechanism offers a more straightforward approach by having a purchase price agreement upfront at completion. But here, the buyer faces the risk of a gap between the transaction price and the value of the target at completion. So I think it's important that the buyers, in this context of the lockbox, negotiate appropriate protection in the SPA for value leakage prior to completion to ensure that the box is really locked. In this context, we help also our client to review the cash flow, inflow, outflow over the period from the locked box date to the completion date in order actually to identify any potential leakage other than the permitted leakage.
Thank you very much, Najla. Laurent, so Laurent, our partner in charge of financial advisory service in Mazars, Vietnam. From your point of view, what about the price structuring? Now we are talking about price mechanism. From your side, price structuring, what do you think?
Thank you, Thomas. So price structuring is very key. It comes very handy when you get at this stage of the transaction. Both parties may be interested, but you have to manage sellers' pricing expectation, buyers' expectation. A seller would argue, would base on future value, looking at forecast. A buyer would be willing to pay for what they actually see as an ongoing business. So this is where mechanisms like an earn-out, call options can come very helpful to manage the negotiation. So from a buyer perspective, and if we take the example of the earn-out, what does it bring to a buyer, right? It helps a buyer to eliminate uncertainty over the purchase price. by fixing a portion of the price to now and having a variable portion over future actual performance. It can also help from a incentive, motivational aspect, as you may want to lock some key management in the company to actually deliver the business plan and the business case they have been using for this valuation. From a seller perspective, key considerations will be, is the earnout attractive enough, achievable for me to accept as a seller to delay a portion of the purchase price to the future? And what about the earnout drivers? Are they, is it possible to have them manipulated? So those considerations will be very key. Now, in terms of metrics, we see financial metrics and non-financial metrics. Financial metrics, the most classic ones would be EBITDA, gross revenue, gross profits, growth of revenue. Non-financial metrics, operating metrics, you would see things like retention of customers, key employees, product launch, and so on. Earnout period, in practice, we see it mostly from 1 to 3 years. The formulas can be more or less complex, often include a cap for the buyer to have visibility on the price. A seller will often try to negotiate a floor and have it on an escrow account. And we see in some situations also a complex structuring with different tiers, different targets to unlock different sort of variable portions. Now, one key element to the earnout as well is how do you measure it? So when it comes to financial metrics, you will need to have certain considerations in mind. What accounting standards do you use? What accounting policies? Are the post-closing accounting framework the same before and after the deal closing? And this is where sometimes buyer and seller may require auditors or financial advisors to actually work on those financials for the earnout period.
Thank you. Thank you, Laurent. Thank you very much. My next question will be for my partner, Bérangère Reusch, from the office of Singapore. So as a lawyer, the key document, of course, as we said, is the SPA. So you take the pencil, you have this big exercise to gather conclusions from due diligences, take into account the LOI. Could you share a bit with us what will be critical for you in overtaking the SPA? What are the pitfalls? And perhaps a question that might interest the audience, what is the balance of power between purchaser and seller in your jurisdiction? That is Singapore and ASEAN.
Yeah, thank you, Arnaud. Hello, everyone. Yeah, so as I practice in Singapore and Asian now for more than 10 years, I think it's fair to say that Asian and Singapore are market friendly, are buyer friendly markets. So the buyer is really in a strong position. Why is that? Well, I think the explanation is twofold. First, from a cultural perspective, the buyer is the one with the money. So it has a strong position. It is thanks to the buyer money that the deal will be made. And then secondly, it's a risky market for the buyer because quite often in Singapore and Asian, the seller is either an individual or a family. So even if the buyer has included in the SPA some very sophisticated mechanism, at the end of the day, if the buyer decided to sue the seller, the buyer might not be able to get either the sentence enforced or to get the financial indemnification effectively paid by the seller for multiple reasons, because maybe the seller has spent the money, has no more assets. So that's why for the parties, it is quite important to discuss a buyer's protection scheme at the stage of the LOI. It's very important for both parties to discuss quite early, as explained by Marie from Havas earlier, to discuss these main terms and this balance of power at the stage of the LOI. Having said that, as you said, when we draft the SPA, we always take into account the LOI and the due diligence report. Because for us, it is key to have them in mind and to reflect all the risks identified during the due diligence exercise to make sure that all these risks are properly assessed and dealt with in the SPA. We try to mitigate the risk identified in the due diligence, all of them, but in particular those that could result in fines or penalties or which might jeopardize the business itself. And we also try to identify the undisclosed risks. So that's why we'll spend quite a lot of time drafting the warranties and the indemnities for the SPA, and this requires very close collaboration with the client.
Thanks, Bérangère. Speaking of indemnities and warranties, and especially for our audience that mostly comes from Europe and city law countries, Nicolas, would you help us to understand the difference of and also the purpose of indemnities versus warranties?
Sure. So I'll try to be brief and to make you understand the difference between these two contractual protections in 2 to 3 minutes. As you said, Arnaud, the concept of warranties, indemnities is not known in civil law jurisdiction. And these are two important tools, I would say, that provide protection to the buyer, but they serve different purposes and have different implications in terms of risk allocations. So first of all, why warranties and indemnities are important for a buyer? Because the fundamental principle in common law jurisdiction, like Hong Kong or Singapore, is the concept of caveat emptor, buyer beware, meaning that the buyer is responsible for checking the quality and suitability of the assets purchased, shares or any other type of assets. So in other words, a buyer will purchase at its own risk. It is therefore critical for buyers to negotiate contractual protection in the SPA. So they have warranties. Warranties, in a nutshell, are statements made by the seller regarding the status of the target company. I'll give you an example. The seller will represent and give warranties on the fact that the company, the target company, has complied with all applicable laws. The company has not breached any commercial contracts. There is no pending litigation, etc. If there is a breach of such warranties, the buyer will be indemnified, will receive damages. An indemnity, on the other hand, is a promise to compensate the buyer for specific losses arising from a breach of contract or the occurrence of specified events. I'll give you an example. You may have in the SPA a buyer requesting the seller to indemnify him for any loss arising from a pending dispute, depending on the outcome of such dispute, or for any tax loss arising from a tax investigation, for instance. An indemnity has a number of advantages over a warranty. I'll probably give you two main advantages. The first one is that usually indemnities are not subject to limitations, so no monetary limitations such as thresholds or baskets, and are not subject to qualifications. Typically, the fact that the buyer may have a knowledge of the risk will not prevent him from making a claim. And secondly, it's easier to determine the amount of the loss to be compensated when you have an indemnity, where usually the compensation is on a dollar-for-dollar basis, while for breach of warranties, you'll get damages, but you need to prove that the breach has caused a reduction of the market value of the target company, which is not an easy task to prove.
Okay, I think that's helpful, Nicolas. Bérangère, again, so we're speaking about indemnities, warranties. You are also highlighting the potential risk for a purchaser to make an acquisition in ASEAN, typically. Could you share a bit more the kind of protection that a purchaser will seek throughout SPA?
Yeah, so on my side, I'm talking about the protection of the seller, and then Fanny will follow up with the protection of the purchaser, but that's fine.
Start with the seller then. We were speaking about the purchaser,
exactly,
but yeah,
exactly.
Let's speak with the seller first, and Fanny, you will discuss about the purchaser protection.
So as I was saying earlier, Singapore and ASEAN are buyer-friendly markets. So it doesn't mean that there is absolutely no protection that are available for the seller in the SPA. But the first thing to note about that is under most of applicable laws in Singapore and ASEAN, the seller has no protection. So it's very important to make sure that the protection that could be offered to the seller are included in the SPA. And I will just illustrate with two simple and market practice protection that are usually agreed by the buyer. First is the disclosure mechanism. So in Singapore and ASEAN, the due diligence is won't be most likely disqualified as disclosed. So it means that the seller has to work on a disclosure letter, which is a document prepared in connection with the SPA. The purpose of the disclosure letter is very simple. It's to disclose to the buyer any known issues or risk related to the share being sold. And so it's a very painful exercise. We usually work with the client to draft it, not only the shareholders, but it's very important to also involve the management of the company to make sure that the disclosures are extensive. What is the benefit of having a disclosure letter from a seller's perspective? First, it limits the scope of the representation and warranties as disclosed as explained by Nicolas earlier. It prevents the buyer from making claims against the seller for issues that were disclosed in the disclosure letter, because the parties will consider that the risk has been disclosed and the price has been adjusted accordingly. Then it also provides a defense against claim, because if the claim has been disclosed in the disclosure letter, then the buyer is aware and could not ask for anything else. And then the last thing, which is helpful with the disclosure letter, it helps to avoid post-closing dispute. If the buyer is aware of an issue prior to the sale, they are less likely to make claim against the seller after the sale, provided it is properly drafted and explained in the disclosure letter. So it's a quite important document.
Okay.
Then the second mechanism that we usually see, and I won't go into too much detail in that, is it's very important for the SPA to include cap and de minimis protection for the seller's liability. It is important to note that in Singapore and Asia, the caps are most of the time between 70% and 100% of the consideration, so they are quite high compared to Europe, but it doesn't matter. It's quite important to fight to have a cap, even if such cap is high, and it's also quite important for the seller to fight to have a de minimis provision. They provide a good protection for the seller. In particular, it prevents against frivolous claim, and it avoids too many discussion with the buyer. So maybe. Fanny, now you want to discuss about the buyer's rights?
Yes, thank you, Bérangère. Just to quickly come back on the disclosure mechanism, which protect actually the seller. In China, from the buyer side, what we usually clearly state in the SPA is the fact that we perform due diligence does not exempt the sellers from the liabilities. This is something that is actually key in China. We also, when we draft the SPA, we also have to keep in mind from legally perspective that the shares in China are only considered transferred to the buyer upon the completion of all the administrative formalities with the AMR, which is the Authority of Market Regulations. It's a long process, and sometimes you have back and forth discussion with the authorities. So when we draft the SPA, we, from buyer side, tend to negotiate actually not to make the payment of the purchase price before the completion of such formalities. So it's a tough negotiation that we usually have with the seller and with the advisors. Regarding the reps and warranties in the SPA, there's something as well, because there is in China a strong difficulty to execute some of them, mainly due to the control of the SAFE, which is the Administration of Foreign Exchange Control. And we do recommend in this case that the compensation or the indemnification we mentioned before, initially granted to the buyer, can be given actually or paid to the target company. So it stays within China. And like this, we also avoid the SAFE control. Finally, in terms of buyer protection, there's something interesting to point out. It's the non-competition clause. Having a Chinese partner engage in the near future in a similar activity than the one you have just purchased is still a risk, a tangible risk in China. So that's why we usually recommend keeping the Chinese partner as minority shareholder, even for a few years, until the risk is considered to be low enough for the company to acquire the remaining shares. And this is actually part of the negotiation we discussed before regarding the pricing mechanism.
Thank you very much, Fanny. Now we are coming to the end of this session. We have just one last questions. So last question is for Hong Chuan, our partner in charge of M&A in Mazars, Singapore, and Jean-François, so in Japan. Once everything is negotiated and agreed, so the last part is the integration of the target. So from your point of view, what is important to pay attention regarding the post-merger integrations?
Okay. Thank you, Thomas. Hello, everyone. Before we talk about post-merger challenges, I think I'll start with challenges that actually could begin from post-signing. So as you can imagine, normally in a deal, intensity builds up towards signing a definitive document. In this case, I take SPA as an example. And sometimes after this milestone, we see the responsibilities actually passed from the M&A team to a completely different set of people after the deal, such as local management. The problem with this is that first, if you, in this case, quite often you actually need to pass on information from the M&A team to the local management. And this needs to happen, but sometimes the transfer of knowledge is just not complete. And we also see situations where people who is now involved in post-signing sometimes have no experience in transactions at all. And in some cases, they actually have little context in the target or even agreement that has been signed. So in this situation, for example, during closing, the team who is tasked to do the completion, they will be facing many challenges. So, and they are being tasked to implement the intention in the SPA. In some extreme situations that we have seen in the past, we actually do see situations where the team will struggle to do the completion that Najla mentioned. They are tasked to do completion accounts, but because they're not familiar with the deal, this becomes a challenge for them. Another situation that is a bit more extreme that we have seen is sometimes during due diligence, we flagged out post-merger integration issues. And these are certainly issues that they want to resolve. But after years, sometimes they are not even resolved after a long period of time. Another scenario that we have encountered, especially for deals with earn-out mechanism, which Lauren shared earlier, is that this mechanisms actually requires a very close monitoring of the deal after closing. So during this period, during the earn-out period, when you have a seller who continues to stay on and manage the business, they are doing day-to-day decisions and making decisions that will drive the business. You can imagine in those situations there will be opportunities for such owners, ex-owners who are now driving the business to maximize in a way that maximize their earn-out. So this will be at the expense of the long-term well-being of the business. And you can imagine if they kind of dismissed and are behind in terms of long-term investments, this will make the company be behind and not be able to grow at a stage where the buyer is expecting. So in these situations, post-merger, it needs to be managed on a day-to-day basis. So it's not something that you simply look at once a year. And we have actually been helping our clients, especially in China and Japan, in such situations. I'll let maybe Jean-Francois, who is very familiar with this country, share a bit more.
Yeah. So thank you, Hongchuan. And you know, Hongchuan just presented a few, I would say, technical aspects of the post-acquisition. You know, the fact that we need to follow on with issue identified that has to be solved post-acquisition, or also about, you know, management of earn-out that can be extremely important. I'll focus on something that is more operational, which is how the buyer has to take control fast and actually over the target. The first thing is about fast. You know, very fast after the closing, it's important that the buyer controls the target, and it's about legal issue. So, for example, changing the board in order to reflect the new ownership, but it's also about very pragmatic aspect. You know, getting access, getting control over the money. You know, having changed the authorization at the bank. So, because at the end of the day, that's what it is about. It's also a specificity of most of Asian country. We have here this shop or stamp concept, you know, where the person who has the stamp, who has the shop, is the one who can engage the company. So it's extremely important that at the time of the closing, you get the shops to have the actual control over the company. And we had cases, specifically when I was in China, where this was not done, and months and months and months after, the actual control was not transferred to the buyer. Leading to the second part, the actual control. What do you need to have actual control over the entity? First, you need to be involved actively in any major decision of the entity. It seems trivial like that, but it's not that easy when you're acquiring a company where the decision-making process is not structured, specifically when you are in a deal where you are buying from a founder or from a strong individual who was managing the business before. The second aspect, you know, in order to take good decision, you need to be well informed. And very often, the structure of production and transfer of information is not the one you are used to, or even doesn't exist at all. Again, you know, historically, the owner knew the business and didn't have a very structured, elaborate reporting system. So all these are things that you need very quickly to implement, as well as, of course, to implement your business case, echoing what I said before, you know, about the necessity to have a business case that produce benefit. What does it mean? It means that you need to implement what we call a post-merger integration plan. Meaning, one, you need to map the situation. What is the present situation in the target? You need to design a target organization, and then you need to have a transition plan with somebody who is making sure that what you want to implement is actually implemented. It's not that easy in a highly contextual culture like China, Japan. I mean, it's clearly a big issue we see in Japan, where there is a strong resistance to change. How you can do that? The first solution, probably the best one, is to have your own person, your own man, woman, moving from the headquarters, from into the group to the newly acquired entity. But it's not always possible because we may not have the resource. The company might be too complicated for that. In that case, it's important that you find local consultants that are on site and are able to do the bridge between the headquarters and the local entity, and make sure on a very systematic way that the PMI plan is implemented. So now, you have, sorry, go ahead.
Please. Thank you, Jean-François. We are on quite close to the end, so we are at hours. So maybe we can take the opportunity to have one last word from each of your jurisdictions about the current trend that you seen in terms of M&A situations. As we have such a large panelist from different countries in Asia-Pac, it's a good opportunity. Maybe we can start with mainland China. So Cindy and Fanny, some few words about the M&A trend in your jurisdictions.
Cindy, maybe you want to start?
Okay. I think in China, of course, we see the sort of increasing trend after the lifts of the border restrictions. We see a lot of deals trying to push to a close for completion. I mean, here, the final words from me, it would be that the M&A is not an easy process for most people. Sometimes it may be the first or only time that you go through the process. So you definitely need sort of professional advisors to guide you through the process, but still you need to prepare for surprises. I think in China, like what we mentioned in the webinar, there are big sort of compliance costs that may be flagged during the M&A or deal process. So I think the most important is to understand as much as you can during the process what you are buying, how you are buying, and whether it worth what you are paying for.
Fanny?
Yes. Thank you, Thomas. Thank you, Cindy. For me, the trend is definitely, I can see a trend for M&A transaction to come, and the fact that we get out of COVID, actually, it increased this trend. The legal environment in China is becoming more sophisticated and closer to the standard we have as well in Europe, but we still have very strong local practice and formalities that we need to accomplish. So it's like what Cindy mentioned, it's a long process, it's a very long process, and there's also a need to educate along the process. What we do not see often right now in China, but I'm sure we will see it more often, because again, we have a strong trend of M&A transaction, is the fact that the seller will consult probably advisor more and more for vendor due diligence. And when we can see that this will happen, it will definitely probably smooth the process.
Thank you very much, Fanny. Again, for the audience, don't hesitate to use the Q&A box to ask your questions. We will, after just this roundtable, we will go through the Q&A sessions. Next country, territories, Hong Kong, Najla and Nicolas.
Najla, please go ahead if you wish
You're
to start.
Mute, Najla.
Okay, sorry. Yeah, maybe for Hong Kong. Actually, Hong Kong has a head start in recovering from the pandemic restriction, and I mean, for sure, it's slowly recovering from all the 3 years of COVID restriction. Adding to that, the macroeconomic environment, interest rate, etc. For sure, this will have an impact on the growth, I would say, in 2023. But then Hong Kong is recovering, so it will remain an attractive hub for both inbound and outbound investment, particularly as well for Chinese companies seeking alternative option. So I would say it is picking up here. There are many growth and profit opportunities for business, for M&A transaction, considering the financial institutions environment, considering as well the strategic business location of Hong Kong. So there are some challenges in the coming years, but it is actually picking up here, hopefully.
Thank you, Najla. Thank you, Najla.
However, you want to...
Well, I would just add that I don't know if this is a trend, it's more continuity, is that investors, buyers, sellers, still rely on the legal environment in Hong Kong to do M&A. So with the pandemic, many M&A transactions were put on hold. We are seeing over the past 2 to 3 months a huge recovery. It's rebooming again. But yes, Hong Kong still put forward the rule of law. The common law jurisdiction is very well known for investors all over the world, and buyers, sellers still, if they have the choice, prefer to structure their investments through Hong Kong and apply Hong Kong law, which is the current norm and norm for the business environment, very friendly to investors in their deals. And a last word as well, quickly, we've discussed this. The past trends is more VDD, vendors due diligence, lockbox mechanism to speed up the process, and probably the use of warranty and indemnity insurance policy. But I've seen that there is a question, so maybe we will elaborate on this.
Yes, let's move perhaps to Japan, Jean-François, because we have Singapore, Vietnam, and then we will end up with India, Japan. Let's go.
Okay, I'll try to be short. What we see in inbound investment is picking up, and frankly, mainly thanks to China, because there is a certain distrust, I think, by investors now vis-a-vis China, and we see that they are coming to Japan now again, or they are returning to Japan. The second point, if we look at local deal, and I know there was a question in the Q&A, we see more distressed asset transaction here in Japan. But that's probably a difference with the rest of Asia, because we are probably in a more mature economy with company with a different type of history. What we see also is more secondary deal. What I call a secondary deal is Japanese company that were already invested by a foreign investor. There is a certain strategic focus that would lead a foreign investor to sell the Japanese entity either to another foreign investor or to a Japanese investor. And what we see also now is also picking up very much is the outbound business, meaning Japanese company trying to acquire in the States or in Europe or in Africa. We did that recently. Based on the fact that the Japanese economy has not been growing very fast, for a Japanese investor, if they have already a big market share in Japan, the only way to continue to grow for them is via M&A outside of Japan.
Thank you, Jean-François. Singapore?
Yes.
Yeah,
very quite quickly also, and I will try also to address one of the a Q&A question. So in Singapore, what we see is it's very interesting. We see two things. First, the valuation are getting lower and more and somewhat somehow more reasonable. So this attracts new transaction for players who wants to grow their presence in the region or who've decided to start their operation by acquiring an entity either in Singapore or in APAC. And we also see a bit more distressed transaction, which are usually done with a certain urgency to close, and this happened quite a lot last year, with either transaction in equity, but most oftenly through asset deal, because asset deal you avoid a lot of issues that we've pointed during this seminar, and you can just buy the asset without doing too much due diligence.
Thank you, Hongchuan.
Yeah, and just echoing what Berenger just mentioned, I do see the valuation softening as well. So sellers has been asking for a lower price, which is something that I've been seeing in the past. When one effect of that is that I have actually been seeing quite a number of deals that that didn't succeed over the COVID period, that's being revisited by buyers. So that is I think there's a positive trend together with the lowering of valuation that makes it quite interesting for both the buyers and the sellers. And also, as what Jean-François mentioned, outbound deals from Japan, we've been seeing quite a fair bit of that coming into Singapore as well. But one thing that was a bit more interesting in terms of trend is they used to come into Singapore a bit as a gateway country towards the rest of Southeast Asia. But increasingly, I've been seeing more deals where they are looking at Singapore as a primary market where they are investing into. So that's another trend that I've been seeing quite strongly in Singapore as well.
Yeah, and I think on trend, this is also encouraged by the policy of the government that the money is flooding to encourage investment locally, right?
Yeah, absolutely.
Vietnam, Laurent, what news in Vietnam?
So Vietnam remains a quite attractive market. We see a high interest. I think the main drivers are always the high GDP. Even the forecast revisited after COVID, they are still quite high and in the top of Southeast Asia. It's a developing economy, so everything about healthcare, education, consumer has been very growing thanks to COVID. And actually with a touch of digitalization of all of this. So you see a lot of edtech, fintech, e-commerce platform, everything that is kind of accelerated with COVID. I think the pandemic has changed also something. When it comes to valuation, some sellers are kind of used to valuation pre-COVID. And there may be an issue when it comes to discussing with buyers. And I see a trend of more use of structuring pricing with earnouts, seeing two sides trying to figure out how they can manage an expectation of a seller and of a buyer. Because what we see is buyers not necessarily always trying to take advantage of a distressed company, but also actually buying company to see developing and so on, and trying to incentivize the seller to keep that on track. From another, it's maybe less the topic today, but when you look at startup, because it's a very hot sector in Vietnam.
Dynamic.
Yeah, for startup fundraising, it has been more difficult. Venture capital have been maybe having more scrutiny recently. And it's been difficult for startup to raise at the moment. And obviously, like everywhere, the increase of interest rates have made raising financing difficult. So, for example, last week I was discussing with a client. There's an SPA signed, things signed, and so on, but financing solutions are still hard to find.
Thank you, Laurent. Marie, you had the honor to introduce and start the exchange with everyone, and you will have again the honor to conclude with one country that we have not discussed yet about, and I know that Havas is active in India. India is in the spotlight at the moment. It's a very attracting and fast-growing country. Perhaps this is the decade for India. What is your experience about doing transactions in India, Marie?
Hi. If I can say only one thing, is that the deals takes a lot of time. For us, we have been doing few in the last few years, and we are very active at the moment, and I mean for the future as well. For different reasons, I cannot give all because that's a very complex jurisdiction from my point of view, a bit similar as China from my point of view. So because first there is quite a big culture of negotiation. So unlike I just said at the LOI, you know, we try to pre-agree on most of the terms. In practice, India, you can have a lot of last-minute negotiation, even just the day before signing in terms of price renegotiation, terms of the LOI and further of the transaction documents, and you have a lot of complexities. So one of the main one for me being the foreign exchange control regulations that are very strict in India. That's to give just two examples. One is about, so for us, as I say, we buy a majority stake, then we have few years of earnouts and then buyout later. So for the earnout, it is quite difficult to structure it in India, especially if you buy via a foreign entity or a foreign control entity that is in India, where you have to do it as a standalone transaction that goes with a share transfer, because you cannot have a deferred consideration of, I think it's it should be paid within 18 months maximum and not exceeding 25% of the total purchase price, which for us doesn't work with our model of earnout. So it's just an example. And also something very complex because of this restriction is that you have to look from the beginning of the transaction at the status of residency of the seller and the purchaser, whether they are resident in India or not. And that may really complexify the price structure because, for instance, if you are a foreign entity or again, a foreign owned entity in India, and you are buying shares from a resident in India, you have to buy at a minimum fair market value. So fair market value or above. So you have to check with your formula. And reverse, if you buy from, let's say from a seller, you are a foreign, so complex. If you are an Indian resident buying shares in a foreign entity, you cannot buy more than the fair market value. I mean, just to explain in a nutshell that if you have, a mix of all of that in your transaction, that becomes really a nightmare. So just a few examples on why it is so long in India to make deals.
Thank you very much, Marie.
Thomas, we have a few questions I see on the Q&A features. I'm not sure we'll have time to address them all. Perhaps you wanted to start. I don't know how you want to proceed.
Maybe I'll let you start with questions about legal side, and then we see what we can pick up. But just to let the audience know that if we may not have enough time to answer all your questions, don't hesitate to drop us an email. So I will share with you in the next page. Yeah, on this page, you have an email address of all the panelists in this session. So don't hesitate to drop us emails to either Hong Kong on the jurisdictions that you need to get the answer. Don't hesitate.
Okay, I have one question in front of my eyes that maybe for either Nicolas or Fanny. It's about the key consideration for conducting legal due diligence in cross-border M&A transactions between Hong Kong and China, and how we address the different legal system, especially, I guess, Nicolas, when you have a structure where the holding is a Hong Kong company and the China co is in the mainland. Are there any issues to bear in mind for this kind of cross-border matter?
Well, I would say the main issue is not really on the due diligence side, because due diligence, we will conduct a due diligence in Hong Kong, another one for the entities in the subsidiaries in China, and we'll make sure that the target entities are compliant with the local laws, so the PRC and the Hong Kong rules. And it will be covered by warranties, indemnities. We've discussed this. I would say the peculiarity is more on the structuring of the transaction to address difficulties of and differences between the two systems. Marie was talking about the difficulty to put in place earn-out mechanism in India. We have the same difficulty in China, right? When you pay the price, you have a certain period of time to pay the price to the sellers. We don't have this in Hong Kong, so we need to take into account such constraints when you structure the deal. Another example is a tax issue. When you acquire a Chinese company which is held by a holding entity in Hong Kong, there might be tax implications and what we call the indirect equity transfer. There might be notifications to be made to the tax authorities in the PRC, which will have to be anticipated in advance in order to have a smooth signing and closing. I don't know, Fanny, if you want to add anything on this.
Just maybe two things to be quick regarding the cross-border due diligence. I just would like to add the fact that in China, we do have now personal data protection security law that actually change a bit the way to access the due diligence and the data room from China. So you have to bear in mind that it's a different way to access it. So it means that we need to obtain the consent of all the person having access to it, and also maybe the necessity to sign sometimes an NDA. Just quickly regarding the fact that we have transaction between Hong Kong and China, no matter the law we decide to be applicable, China or Hong Kong law, what we have to think is the execution actually of any decision that will come from court. So if you really want to have a discussion, a decision to be executed in China, you need maybe to consider Chinese law. If the seller is outside of China, then it's maybe the Hong Kong law.
Thanks, Fanny. Since we have you, not necessarily a legal question, but do you see a trend for Western MNCs to divest and sell their China business, given an alleged geopolitical risk in the global approach? Do you see this trend, or is it something that is for the moment quite dormant?
I would not say it's a divest like liquidation, but definitely there's restructuring, and China has not the same role in Asia than it was before.
For Western companies or for like companies in general?
For Western companies, I would say.
And quickly, I would say it would depend on the nature of activity of the companies. Typically in the luxury sector, China is still booming. So we're not talking about divestment, but more, I mean, maybe increasing investment. But what is clear is that there is a rebalancing of risk in the region. And yeah, it's more reorganization of activities.
Yeah, and just to add, I think here from Mazars, yes, it's not necessary the divesting, but after a couple of years not being able to sort of send technical expert or management team to China, some company are really running, say the performance is bad or is running at a loss. Say, for example, we have a couple of client, like they need us to do some special sort of testing or AUP, agreed upon procedures around these areas, to investigate like what's happening in all of the companies in China. I think this is what we have seen. But again, I think this is not the topic for today, but this is something we have seen as well recently in terms of any agreed upon procedure works done for our clients.
Okay, thank you, Cindy. I think geopolitical issue, maybe not in China, but more restructuring because the business maybe is not enough profitable. Here we have also another questions about post-merger integrations. So yes, how do you, I think maybe it's a question for Laurent or Cindy or Najla, how do you manage gap difference between the two different accounting gap when you integrate a new entity? I think maybe we have this case in Vietnam and China.
Thanks, Thomas. Share Cyprus, and Laurent, you can add your comment to Vietnam. I think here in China, there is difference between GAAP and IFRS, of course. So the GAAP difference needs to be sort of dealt with. Say in China, you have accounting standards for business enterprises, which is very similar to IFRS. And there is another one called accounting regulation for business enterprises. Say the definition of fair value, the inventory valuation, the application of IFRS 16, this can be very different. So I guess for first instance, this is something you can add as part of the due diligence to add a scope, I mean, to identify the difference between the local GAAP and IFRS and to identify the impact on the valuation. And second, of course, post-merger integration. That is something you can prepare sort of, say, different sets of accounts for different accounting standards.
If I may add something, Thomas, here, the point is frankly not that much between accounting gap, because, you know, the accounting gap are relatively similar and we can easily manage it. The question is more about, you know, doing a proper accounting and doing an accounting for tax evasion in China or for tax compliance in Japan. That's more the issue. And so it's more about educating your CFO, your financial controller in the acquired entity. I would say that works for 50% of the case in the PMI process. Let's be honest, in 50% of the case, it's you need to put the proper CFO in the entity and fire the old one.
Okay, thank you very much. Maybe last questions. We are quite close to the end. Maybe quite interesting is about how long it will take to identify a target.
Yeah. It's true that we have not raised this point during our on purpose. We started from the non-binding offer and NOI status, and we have not raised all the research and target identification. I don't know if Thomas, who do you think could perhaps discuss about this?
I think maybe Japan, so Jean-François, or maybe someone.
Again, yeah.
No, I think for the target identification, that's for Marie.
Marie, how do you find targets?
Yes. Sorry.
In Japan.
Coming back. Hi. I think so. To be honest, I may not be the best. You can hear me, right? Yeah.
Yes. Okay,
I may not be the best place because for me, I'm mostly in charge. So my role usually, there is another person, Margot, in my team. She's the one, so more on the financial side. She's the one, so usually we have our local CEO, we have markets where we invest quite a lot in APAC, but we have a priority market that I cannot disclose, but so usually the CEO in the relevant country is the one that is having the connection. Then Margot, my colleague, is coming to the picture to understand what is the business, what is their strategy, how we want to build, to grow in the country. So they will meet have chemistry meetings. So usually for us, we don't use broker, but maybe depending on certain countries where it's a bit difficult. So difficult to advise on the length because then they will have chemistry meeting, then there will be a discussion on NBIO, so non-binding offer. So before the LOI about our structure of valuation, there will be back and forth. So could be, I mean, for us, it's quite long. I would say around, it takes a few months for sure.
Yeah, thanks a lot, Marie. In any case, I think it's a topic that would perhaps require a full webinar, perhaps a next topic for our next session. Thomas, I think we can come to an end and thank all our audience for attending, and again, the organizers.
Yes, thank you very much. So it's 5:30 here in China, maybe 6:30 in Japan.
Right on time. Very good.
Right on time. Thank you, everyone, for the audience for your participation. Thank you, the panelists, and thank you, the Chambers of Commerce in Singapore, Japan, China, Hong Kong, to organize this amazing webinar. And thank you.
Bye, Thomas. Bye, everyone.
Thank you. Bye-bye.
Bye-bye.
Thank you. Bye-bye.
Thank you. Bye.
Thank you. Bye-bye.
Bye.